this is just a quick rundown of a review for the family law quiz that's coming up. It only covers the chapters on adoption, which is chapter 8 in your text, and the chapter on child custody, which is chapter 9. For adoption, we talked about types of adoption, dependent on who sets them up or facilitates them. So agency adoptions, ones that are either facilitated or set up through a state agency or an organization or agency that is affiliated with the state. We also looked at independent adoptions. Those are ones that are set up through private organizations, or sometimes they're just through private parties. This would cover a situation when a family member adopts a child, or perhaps a church member adopts a child from another church member. There is less oversight by the government into these independent adoptions. With adoptions that are set up through state agencies, home studies are conducted, investigations of the adoptive parents are done to make sure that they're suitable adoptive parents and that the home is a good and safe environment for the adopted child. So there's a little less oversight. As a benefit, though, for these independent adoptions, usually there's more contact between the adoptive family and the biological family because they generally had some connection before. They went to church together, they knew each other somehow. We also talked about open versus closed adoptions. An open adoption is one in which information about the biological parents is going to be available to the child or to the adoptive family. Sometimes there's a minimum age for the child to reach before that information is available, but it is available. In a closed adoption, information about the child's biological or natural parents is not available. That is, they can't ever open the records to see who their biological parents were. A couple of states make an exception for medical emergencies. We talked about adoption being importantly a two-step process. The first step that has to happen is that the biological parent's rights must be terminated. We sometimes abbreviate that as TPR, termination of parental rights. That can be done either voluntarily, as the parents consent, sign away their rights to their children, or sometimes it is done involuntarily. That is, the parents don't want to give up custody or rights to their children, but the family court has determined that the child is not going to be safely reunited with that family, either because of issues concerning abuse, whether that's physical, sexual, issues concerning safety in the home, whether that is because of a mental illness or substance or drug abuse problem with the parent. It may be because the parent has been incarcerated for a long period of time. So parental rights can be terminated by the court against the parent's wishes. Usually that only happens if the parents are not participating in a reunification plan. That is, normally they've got steps that they have to complete in order to have their children back home. Sometimes that involves substance abuse counseling, sometimes that involves anger management classes, it might involve parenting classes, depending on the situation. But as long as the parent is participating in that plan, generally the courts will not terminate their parental rights. It's usually a last resort. If it looks like there is no chance for that child to go back to the natural family, then the courts will terminate their rights so that the child is freed up for adoption. We covered also putative fathers and putative father registries. A putative father is someone who believes or suspects that he may be the father of a child, but that hasn't been determined yet legally through a DNA test or a court order. A registry is something that's set up by the states that allows the father to put his name on a list saying basically that he believes he's the child's father. This helps to protect his rights in case the mother wants to put the child up for adoption without his knowledge. the state would run his name against that registry and see that he is an interested party. We talked about permanency planning being the goal of most family courts in adoption cases. That is, the courts view permanency as an important factor in a child's development, meaning that a stable and secure home environment is good for their development. The courts do not want kids to be moved in and out of homes or uprooted any more than they have to be for their own benefit. TPR, again, just stands for termination of parental rights. Your textbook covers some of the grounds for terminating parental rights. Again, it's not about whether the person is the best parent on the planet. The question is whether or not they can provide a safe, secure, and healthy home environment. The next chapter that we looked at focused on child custody. It looked at both physical and legal custody. These are two separate types of custody that the courts determine. So physical custody means who the child lives with. Legal custody means who has the right to make decisions for that child about where they attend school, or where they attend church, whether they get medical treatment or see a counselor. Anything that's of significance in the child's life, legal custody means that the parent has the right to make that decision. Custody, both physical and legal, can be either sole, belonging to just one parent, or it can be joint, split between the parents. Two parents can have joint legal custody of a child, but it may be that only dad has physical custody. That means the child only lives with dad, but that mom and dad both have a right to be consulted about decisions for the child. We also have something called split custody, and that is pretty uncommon. Split custody does not mean that physical and legal custody are split. Split custody means that there's more than one child and they don't live with the same parent. So if you have a brother and sister, split custody means mom has custody of the son and dad has custody of the daughter. That's split custody. Courts do not prefer to do split custody because it's not good for kids in the court's view. There is an advantage to being raised and having a relationship with your siblings, so the court tries to promote that unless there is some good reason that the kids should not live together. That is, maybe one of them is bullying or abusive to the other, or one of them has a very negative relationship with one parent. So unless there's some good compelling reason, courts do not like to split siblings into different families or different homes. Turn a little bit to the last one there. Finally, we looked at some standards for how family courts determine custody issues. We looked at some old or traditional standards. They were largely based on gender assumptions. So we had a maternal preference, a paternal preference, and something called the tender years doctrine. Tender years really just said that young children, toddlers, and infants were better cared for by a mother because they were a more nurturing parent. Again, we know that that's not always the case. Those old standards have been replaced with more modern standards. The most important of those is best interest of the child. That is the most commonly used standard for determining child custody. What's in the best interest of the child? Courts generally feel that it is in the child's best interest to have a relationship with both parents. Again, unless there are some circumstances, abuse, drug use, incarceration, unless there's some good reason why a child would not benefit from having a relationship with one parent. We also talked about the primary caretaker standard. That just says in courts that use it, or states that family courts use it, that whichever parent had been the primary caretaker of the children prior to the divorce should remain the primary caretaker. So if mom was the parent who got the kids up for school, made their lunch, got them dressed, gave them baths, put them to bed, etc., then mom is likely to be the custodial parent. If dad did those things, then dad is more likely to be the custodial parent. We also talked briefly about the ALI's approximation rule. It is not used that commonly, but it essentially looks at percentages. Which parent spends what percent of the time caretaking for the children, and that percentage should be reflected in custody. So if mom spent 70% of the time doing child care before the divorce, mom should have custody 70% of the time. We talked about a guardian ad litem being a person appointed by the court to represent the child's interest. They do that by conducting interviews with the child if they're old enough, talking to the child's teachers or family members or counselors or pastors, coaches, whoever might know about the child's life and what's important to them. We also talked about some factors that affect child custody, that is, factors that are likely to influence which parent has primary custody. Those are covered on page 319 to 327 in your text, but they include things like health, availability, stability, okay? And which parent is likely to be the most cooperative parent. And when we say cooperative, we're talking about their willingness to encourage and facilitate a relationship with their ex-spouse. Okay? So a parent who wants to encourage their kid to spend time with dad is more likely to get custody than a parent who tries to keep their kids away from their ex-spouse. We also finally discussed modifying custody orders. It is a challenge to modify a custody order. Courts, are aiming at stability for the kids. Because of that, we don't want them in court every 6 months trying to decide who they're going to live with next year. So unless there is a good reason to modify a custody agreement, the courts generally do not want to change them. Lastly, your textbook looked at third-party visitation rights. That is, what rights, if any, do grandparents, aunts, uncles, cousins, extended family members have to see children? The parents' wishes are elevated above those of third parties, extended family members. But if the court finds that it is in the child's best interest to have visitation with grandma or grandpa or whoever, then the court can order that. I think that's it. Good luck for your quiz, and we'll see you soon.